You were invited doing it. Good morning. This is Pat O'Connell. I'm calling to order the New Mexico Public Regulation Commission's regular open meeting for Thursday, March 6th. It's 10 a.m. We're here in the Bochum building and also broadcasting online. Mr. Cameron, can you call the roll?
Commissioner Nybert, Commissioner O'Connell,
Here.
Commissioner Aguilera, present. All commissioners are here and you have a quorum, Mr. Chair.
Great. So first up is Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico, the symbol of perfect friendship among united cultures.
Okay, so commissioners, we have an agenda in front of us that was posted on Monday morning. Any need for a change to that agenda? Seeing none, we will proceed with the agenda as posted. So next up is public comment. Is there anybody here who'd like to provide public comment? Room's a little spare today, but so seeing none, Mr. Rodriguez, is there anybody who's registered online to give public comment?
Mr. Chair, we don't have anyone online for public comment.
Okay, thank you. Next up, announcements. Mr. Cameron, do you have any?
Thank you, Mr. Chair. Just a quick one to let the general public know that our next meeting, which is going to be on March 20th, we are going to have a late start at 11:30 instead of the usual 10 a.m. start. We'll post the agenda and all that good stuff. I want to give everybody a 2-week heads up.
Great, thank you. And then, this meeting, we're in an interesting day because it's supposed to be super windy in New Mexico. So this new tool that electric utilities have been using across the country to help prevent devastating impact of a wildfire, public safety power shutoff. We were notified that that could happen in Santa Fe today. So I think that's kind of impinged attendance at this meeting, which is okay. But I was curious to see who P&M would send to sit in the dark with us. We worked through that scenario, and just for edification, that if the workday starts and we start this meeting in this room, we're going to keep powering through the meeting, even if the lights go out, if that's the only thing that happened is the lights went out. So the meeting will continue if we do experience a power shut off. And then the subsequent communication we receive from P&M makes it look like unlikely that it's going to happen at this building. It might happen in Santa Fe. So anyway, we've got some notes for you about how this communication can improve. I would say that all the utilities are experiencing this, and it's a trial and error, and some of it is a feature of your service territory and your customer base, but also interesting how each one of them was figuring this out on their own. Apparently, there doesn't seem to be a lot of coordination or communication and learning of best practices across the utility space. So if there's something I can do to improve that, love to know about it. And then the other thing that makes that an announcement for this meeting is this week has also highlighted something that we've been talking about over 2 years, haven't really got there, is internally within the commission, we need to understand how to share information better. Like I was talking to SPS over the weekend about the situation in Roswell that was earlier this week, and was told, well, the utility division staff is getting all these emails. I'm sure they're sharing them. And like, I have not received any of those. So we need to go back and double check internally what, who needs to be informed. Like certainly Mr. Rodriguez should be on the list. Commissioners probably should be informed, but not necessarily that we're going to do anything about it. But we just need to run through that, whatever our internal protocol is for communicating days like today. And then after all that, the other thing I like to do in the announcement section is talk about opportunities to see the commission in action between now and our next meeting. And strangely enough, we don't have any hearings scheduled between now and March 20th. So we do, as Mr. Cameron noted, we will start the March 20th meeting at 11:30 instead of 10. So for those of you planning to attend on the 20th, get an extra hour and a half. Okay, any other announcements? Seeing none.
Actually, Chairman, I think, going on to your point about the wildfires, or, not, sorry, I'm thinking ahead, power safety shutoffs. We do have this wildfire docket to talk about precisely notice that needs to be provided and when. I think it would be helpful to also talk about in the future what kind of notices have been shared for this particular instance to customers and the public. I know about this because it's my job, and so I've heard about it, but I haven't heard really anything about this as a customer. The first I heard was yesterday that my son's school is going to have a remote learning day. And so, so the schools know, obviously. I also had some concerned calls from the city about this. And so the city knows, obviously, but they feel like there is room for improvement as well. And so that conversation is going to be really important to talk about what kind of notice is appropriate and when. So not jumping to conclusions and saying that anything has been inappropriate right now, because I understand that there's also the possibility of creating fear unnecessarily, right? And so there's some type of calculation that goes into it. It involves humidity, wind speed, a lot of other things. And so I think that's something that we should focus on, and also invite municipalities and government people to talk about what their concerns would be. Because we look at it from one side of like the utility here easily, that there could be potential wildfires caused and liabilities. Then there's also impacts that happen to the community and businesses of just shutting off the power. Anyway, it's something that we should focus on, I think. Thank you.
Yeah, thank you, Commissioner. Okay, so next on the agenda is Employee of the Month, and Commissioner Nybert, I believe you have the pleasure of that.
Mr. Chair, it certainly is my pleasure to be the recipient of this fine award. For those of you that haven't seen it before, here it is. And fortunately, I get to have the honor of presenting that to our Employee of the Month for the month of March. And with that, let me read the certificate that recognizes this person. The New Mexico Public Regulation Commission hereby recognizes John Kreinkamp as the NMPRC Employee of the Month for the month of March of 2025. Whereas Mr. John Kreinkamp serves as a hearing examiner in the Hearing Examiners Division at the New Mexico Public Regulation Commission. Whereas John Kreinkamp has worked for the PRC for 1 year. Whereas his nomination states, John has been doing a great job as a hearing examiner and agreed to have a meaningful role in the current legislative session. He's effectively trying to manage 2 full-time tasks. He hasn't complained or protested in any way. As it's his 1-year anniversary, it seems a good time to give him the Employee of the Month award as a gesture by the agency, noting appreciation for meaningful efforts. Whereas John Kreinkamp continues to serve the PRC with dedication and great ability. Now therefore be it resolved that the New Mexico Public Regulation Commission of the State of New Mexico congratulates John Kreinkamp on his selection as Employee of the Month for March 2025, issued under seal of the commission at Santa Fe, New Mexico, the 6th day of March 2025. And at this time, if John will come up and receive his token of our appreciation. Let's go. Thank you very much. Congratulations. Thank you. May you wear it with pride and honor. Thank you very much. Lovely. And when you get back, don't wrestle with the other guy.
What are we, 6 months and that still hasn't gotten older? Yeah. Okay, so next on the agenda is prior meeting minute approval. We've got one set of minutes from February 6th. I reviewed the minutes. They looked okay to me, except for misspellings of a couple names that I tried to edit in Board Effect. Are there any other changes that are needed on the minutes?
I just had the misspell as well.
With those corrections, they look good to me as well.
Okay, so I will move for approval of the February 6th minutes.
Second.
Mr. Kieran.
Commissioner Aguilera,
Aye.
Commissioner O'Connell,
Aye.
Mr. Nyberg.
Yes.
The motion to approve the minutes as amended for the misspellings passes unanimously, Mr. Chair.
Great, thank you. Next up is our consent action items. We have 7 cases on the consent action item list. Any discussion or questions on consent action item agenda? Seeing none, I will move for approval of the draft orders on the consent action items.
Second.
Ooh, dramatic vote coming up.
Your seats. Commissioner Aguilera,
Aye.
Commissioner O'Connell,
Aye.
Commissioner Nyberg.
Yes.
The motion to approve the consent agenda items passes unanimously, Mr. Chair.
Great, thank you. Okay, so first up on the regular action agenda is case 230071 UT. It's ongoing tariff agreements and forms proposed for community solar. Mr. Fisk, you have the floor.
Thank you, Mr. Chairman, commissioners. So this comes before the commission today on the joint motion of SPS, EPE, and our utility division staff for an extension of time to file revised proposed tariffs compliant with the commission's February 7th order, which followed on the commission's order regarding motions for a hearing, which had followed on the commission's order, phase 2 final order from last November. As you recall, in the February 7th order, the commission ordered a number of things, but mostly ordered all 3 utilities to work with staff to confer with them to come up with more uniform presentation of the 3 tariffs and greater detail, mostly in the form of work papers showing the calculations. And those were due on February 21st. All 3 of the utilities actually filed proposed tariffs, but SPS and EPE asked for additional time to continue to improve those. And even though PNM wasn't a move-in, PNM was mentioned in the motion as also continuing to work with staff. So the proposed order would grant the motion, but it would allow the revised proposed tariffs that have already been filed to take effect on their stated effective date of March 19th, because the numbers that they provided are good numbers. The administrative cost rider numbers and the community solar bill credit numbers, those won't change when new tariffs are filed by SPS and EPE and possibly P&M on the 24th, which is the extended date. It'll be the formatting and the detail and things like that. So this order would grant that motion, give them the extension to the 24th. Let these current versions go into effect, and the order would expressly state that subscriber organizations are authorized to use the figures and calculations provided in the currently filed tariffs when soliciting potential subscribers. So they can go ahead and start solicitation of subscribers now. So granting this extension won't slow anything down. With that, I'll take any questions.
Yeah, thank you. Any questions or for Mr. Fisk?
No, I don't have any questions. I think we're working off of a revised version that was sent yesterday evening, late afternoon.
Yes, that is correct.
Okay. Those edits mostly look good to me. There's one, however, two that I wanted to talk about. The first one is eliminating the second paragraph, which is really just a sentence in the introduction. This is a part of the template and intended to be helpful to the reader of the order to know what action or decision the commission is making. And so I think it would be better to add back that sentence or a version of it that explains to anybody who's picking up this order what the commission is deciding. That's one. The other part that I wanted to talk about is in ordering paragraph C, which says what needs to be filed by movants. It seems to me like that might be deleting eliminating PNM. Was that intentional?
Yes. Oh, Commissioner Iver, do you want to speak to that?
Yes, Commissioner Aguilera, PNM's not a party, as I understand it, in this, and so it's really SPS and EPE who we have jurisdiction over, so we should not be ordering a non-party to do something.
Mm-hmm.
And so that's the rationale for that. And for your first comment, that was a finding, so it got moved to the findings. If we want some introduction, it seems to me that we need to put a conclusory remark, not a finding, in the beginning. So it should say, if we want to say something about we conclude in this order that it should be granted, then we ought to say a conclusion, but it shouldn't be a finding.
Yeah, so maybe, yes, I understand and I agree. So maybe as discussed below, the commission grants, and kind of keep going from there.
Yeah.
Okay, I think I see where you're coming from.
Yeah, but because it said the commission
Yeah.
finds that the motion should be granted. We moved that, I believe, later in the under findings and conclusions. I think we moved it, if we not.
Yes.
And so if we want to have some summation of what this order does, we could state that, but it'd be easy that this order, the conclusion of the commission is to grant the revised proposed tariffs, with that language, but it shouldn't be a finding.
Yeah, no, I think we're on the same page. Does that make sense?
Yes, so I could say something like, in this order.
Well, hold on a second. I'd say we're on 3 same pages because what I thought was, let's just replace that paragraph with the commission grants the motion. Just have this is what this thing does on page 1, so you don't have to read all the way to the end.
Okay,
for the
Mr. Chairman,
drama.
sorry, go ahead.
Just replace that paragraph you deleted with a simple sentence says the commission grants the motion.
Okay, would you want no mention of the tariffs being allowed to take effect?
Well, that's the finding that appears later.
Okay,
I mean, it's just the whole. Try to write it in a way that the introduction is tell people what you're gonna say, then say it, and then tell them what you did say. It's just kind of English 101.
Yeah, and that granting the motion, that I think is what I'm what I am concerned about, that should be there. It's just that, the rest of the details could, are explained further below, but.
okay, so I'll just replace it with the commission grants the motion.
And on the first issue, Commissioner Aguilera, do you agree that P and M should be excluded or?
I definitely understand your point that. Well, I'm not entirely sure if they're not a party, but they're not the filers here. They didn't file the motion. They're not movements.
Correct, and yeah, I don't remember a situation like this I've had to deal with before where the movements were in a motion mention one of the other utilities and say they want to do it too. So it's fine with me, just say it's movements. If P&M doesn't file yet another filing, I believe their filing as it is would be okay. They did provide for, but they, apparently they do want to continue to work with staff, so they may file something.
Well, yeah, because they are in this docket, they are a party, and they have been involved in this.
So then is that the movement shall and P and M may?
I think that's the question, is whether P&M has any obligation to file anything. I think if they do, then we would want them to file, but.
And the commission can independently say, we want P&M to continue to work with staff. And so that, because part of this is to create greater uniformity.
Well, we did that in paragraph B. In the parenthetical.
Yes.
Right. And so the solution that the chair just explained could also be might be actually the way to go if there are further changes, revisions we would want them to file.
Yeah, it's funny because I know P and M's listening. I know they know we expect them to do something, so it's just what words need to be there. I think the goal's been accomplished, I guess, is my point, but now we're talking about 20 years from now.
Yeah.
I mean, the commission can independently require P&M to do it. So we could just add P&M. We could say in paragraph C, movements and P&M shall file further. They might not have many more changes that they make, but if they continue to confer, they'll probably have some.
Since P and M is not a moving party for this, I think I would certainly prefer the language that the chair indicated, that we're demanding the movements to file something and we're encouraging P and M to do something. But since they're not really a moving party, I'm not sure we ought to be demanding of a non-moving party something.
Okay, so it'd be in C, it would say movements shall and P&M may file further. Okay. Okay.
And then just in the spirit of yesterday, collaboration is good, so that's part of what's going on here.
And based on that change, I would also need to change in paragraph 13, at the end of the fourth line, it says P&M, EPE, and SPS are in this order required to file for the revised proposed tariff. So I would take out P&M.
That's a good find.
I would just take it out there.
Yeah.
And it would just say EPE and SPS are in this order required to file for the revised proposed tariffs.
Mr. Chair, in that regard, you might want to keep your footnote 10 and just move that to maybe after SPS. Because it does explain that PNM is not a movement, but it has indicated it's working with staff. So the
Okay.
footnote's still good, I think.
Um, I would move to adopt the most recent version of this order as edited today.
I'll second and then open the discussion just to double check that everybody feel good that they know what they're voting on.
Mr. Chair, you know, these are awkward discussions and I've had some discussions with some legislators that were forced to have these awkward discussions because of the ex parte rules that we're under. And it seems that adjudicatory bodies should be able to have these discussions before we show up and render decisions and use the time to explain decisions instead of having to edit documents. So I think that's something that this commission ought to work on with the legislature, is to try to get some really some definitions as to when those ex parte rules apply, and give us the ability to act like judges, if you will, where the Supreme Court or Court of Appeals certainly do not conduct these types of exercises in the court. They do these exercises in their offices, and I would think that that may be a direction that we would want to go. But this is a good example of what should have been done yesterday or the day before, and then present a clean version so that the public could see what we're doing. Because it's probably a little confusing what we just did to everybody out there, but it is important. Thank you.
Yeah, I agree with that. And just as to the discussion about like movements and not adding PNM, that makes complete sense to me. And thank you for catching that, Commissioner Nybert. But I do think that we probably have done some things like that in the past. And so I appreciate that you caught that, because I agree. And then we could also have conversations about the templates and just kind of make sure that we're all comfortable with it. For example, one thing that was added to this, in paragraph 7, no responses to the motion were filed. I completely agree with that. I think that is a simple thing, a simple addition that adds a lot of clarity. And also, just as some a previous analyst looking at these filings, that was part of my job, and I know that writing that sentence in an order forced me to make sure that was true. So going back to e-docket here, back then it was e-library for me, and making sure that there were in fact no comments. And so I think this is a valuable addition, which we've talked about before internally. So I think that's another conversation that we should have, and would be helpful also to OGC, so that they know how to write orders, and we don't put them in kind of an awkward situation where They're kind of, you know, as the chair has mentioned before, it's hard to have a three-headed boss. So, thank you.
Yeah, and then, I mean, I understand and wholeheartedly agree with your comments. It's also just part of the world we're in of trying to move the agency forward, right? So there's two elements to it. It's what you just described plus an element of time. So I just want to thank OGC for adopting this new schedule where we're going to get these documents sooner. So we have a better opportunity to work through the substance of this before the morning of a meeting, because sometimes we weren't even getting this stuff in time to even think about it, much less do something. And I think what happened today was a huge improvement. I think Commissioner Aguilera could express this more eloquently than me. Then another feature is, hey, what happened today was, I think, good instructions to OGC. Hopefully it gets internalized in OGC. So they start, it gets adopted as a practice for all OGC attorneys that are drafting these orders. So anyway, one of these, lots of moments over 2 years where, hey, we just made a micro step forward. This is probably one of those. So thanks to all. Now that we've belabored that, we are ready to vote, Mr. Cameron.
Second to the motion, Mr. Chair.
I seconded it. And then open Pandora's box.
Appreciate that. Commissioner Nyberg,
Yes.
Commissioner O'Connell,
Yes,
Commissioner Aguilera.
Aye.
The motion to approve the order, let's see, the most recent order as edited today passes unanimously, Mr. Chair.
thank you. And
Thank you,
thanks
Mr.
again,
Chairman.
Mr. Fisk.
Commissioners?
Okay. Mr. Gigko, next up is 23-403, which is El Paso Electric Company's application for approval of abandonment of Rio Grande Unit 7 and Newman number 1.
Good morning, Commissioners. As the chair has just stated, this case is 23-00403-UT, which is El Paso Electric's company's application for approval of abandonment of Rio Grande Power Plant Unit 7 and Newman Power Plant Unit 1. The applicant has applied for permission to abandon 2 natural gas-fired steam turbines that came online in 1958 and 1960, respectively. The abandonments are scheduled for January 1st, 2026, contingent upon EPE demonstrating by November 1st, 2025, and in its 2025 Integrated Resource Plan, that EPE will have adequate resources without these units to ensure system reliability. If sufficient capacity is not in place by November 1st, 2025, then the abandonments would be postponed by 1 year, and that pattern would repeat until EPE has the capacity necessary to abandon the units and serve load. This matter is governed by NMSA Section 6295, Abandonment of Service, which establishes a basis for abandonment that continuation of service is unwarranted or the present and future public convenience and necessity do not otherwise require the continuation of the service or use of the facility. Previously, factors called the Commuters Committee factors have been applied by the Commission in order to ascertain that tranche of the public convenience and necessity. Before you are 2 orders. Order number 1 grants the abandonment and adopts the recommended decision in full. Order number 2 grants the abandonment but provides the commission's own analysis with respect to NMSA section 6295 and the commuters committee factors. Significantly, order number 2 does not make a finding that emissions reduction should be considered in the commuters committee analysis. With that background, I stand for questions and turn it over to you for discussion. Thank you.
Okay, thank you for that presentation. Commissioners, any discussion?
Mr. Chair, I don't know how you want to proceed on this. We have 2 orders. I drafted the second order that's before us. So if you'd like me to explain that, I would be happy to do so, or I'd be happy to listen and then respond to the first order, if whatever your pleasure is, sir.
Well, practice has been, especially in this situation, if somebody has got alternate order, that they'll lead the discussion on it. And part of the reason for that is the RD's out there. So everybody's read the RD. So if we're doing something different than RD, that probably merits a little more discussion. So if you take up the banner on the other order, that'd be great.
I'd be happy to. Mr. Chair, the second order that's before you, I drafted as a concern in reading the first order. I felt like the recommended decision went maybe in a direction that didn't focus on the statutory requirements that we have to fulfill. And I was concerned that we were getting focused on some extraneous matters when the statute really requires us to look at the reliability of service to the customers, particularly in New Mexico in this case, and whether or not the utility has presented evidence that those New Mexico customers would not be adversely impacted by the abandonment of these generation facilities. So my intent, and I hope I hit the mark, was to address the statutory requirements, to make findings based upon the information in the record of decision, and to show that the utility has met those statutory requirements upon reaching the statute requires us to approve the abandonment. Thou shall approve it unless we find these other things. So that was the intent of what I did. And so the jurisdiction, the procedural matters are basically the same. The discussion is maybe a little more abbreviated, but basically the same. It does recognize that we can consider other factors, including clean air, and in this case, savings of water. We can consider those things as well, but the statute does not dwell on water or on clean air. The statute dwells on reliability of service to New Mexico customers. So the intent was to address the statute, and so I redid and made some very specific findings under the findings category that tried to address that. I also tried to distinguish what was done in the Four Corners power plant case. That involved the Energy Transition Act and a lot of legislative demands that are not present in this particular case. And so I found it to be not applicable and would suggest that it is not applicable. There is evidence, testimony from El Paso Electric that they currently have sufficient service through their Newman 6 plant to cover the loss of these 2 generating facilities. They also have testimony that references additional generation that will be coming online that will more than replace this. So there's testimony that they currently can meet that need, and in the future will have the additional needs. I recognize that our staff argued the converse and found some of their arguments to be frankly somewhat persuasive, but I'm not in the business of running the utility and really have to rely upon their testimony that they can serve their customers' needs, which they did testify to. There was testimony that reflected that the customers in New Mexico will not be inconvenienced. It will not be a hardship from the abandonment. And that, like I said, the Newman 6 covers the loss of these facilities. The facilities intended to be abandoned are not necessarily reliable. In fact, there's testimony in the record that the boiler went out. They're having to do significant repairs, and they can't just buy pieces to repair these plants. These plants are 60 some years old, and you can't find parts that are going to be acceptable. So they're having to spend money, and they estimated $20 million a piece to retrofit these facilities if they wanted to keep them in use and provide reliable service. And in light of the fact that they're old technology, that they are beyond their natural life, with the other testimony that New Mexico customers would not be harmed, I found that their application should be granted. I then made, I thought, appropriate conclusions based upon those findings, and then like the recommended decision, found that the request to abandon should be approved. We tried to make it give some flexibility to the utility as to the timing of that abandonment as they have proposed in their application. And then the rest of the order is essentially what it was. But this is focused, this order is focused on the statutory criteria. I didn't feel like we needed to go down the road of the recommended decision, and that's why I departed from it.
Great, thank you for that. I guess I'll start off with just reaction to that, and then Commissioner Aguilera, certainly you get opportunity. Just one thing that I like about the alternate that you've offered is it's clear and focused narrowly on the question in front of us. That's interesting in this case because, you know, stepping back in time before you got here, I was working with hearing examiner Ryan on this case. He was wondering what my thoughts were while he was doing his work. And we had a conversation about how long does a recommended decision need to be? And my advice there was I went back to high school English class, and long enough to finish was what I told him. So what does long enough to finish mean? It means that it's clear, defendable, and understandable. So for an abandonment case, this recommended decision is remarkable in its brevity, but I also think it's long enough to finish. So I think listening to your explanation for the alternate you put forward, I think that's another example of that concept, long enough to finish. That if there's a question in front of us, look at the statute that applies and then make a decision based on that. So anyway, I hope I'm not, that's what I heard in what you said. So if I got that wrong, love to hear that too. And then I've got some other comments about this that are not related at all to which order we might approve today. But so I'll save those for later. But then again, going back to hearing examiner Ryan, we couldn't be in this spot without the work that he did. So thank you for that. And then the other thing that just for the world that's watching us, it sounds like we're in agreement that abandonment should be approved. So that's my version of long enough to finish. That's the most important thing in the order, no matter which version goes out. So, Commissioner Aguilera, did you have anything you wanted to?
Yes, I agree with the overall outcome of both alternates, which would grant the abandonment here. And so I just want to say that as an initial matter. The problem that I'm having is that I received this at like 3 or 4 p.m. yesterday and did not feel like I have the full amount of time needed to fully appreciate the changes. And I think there are some important distinctions. So I'm not sure. I do think that this alternate order is focused. I'm not sure that it's clear. That it's clear what our policy is going forward. The RD explains that, you know, we have our statute and our practice was to analyze these types of situations is to determine whether the abandonment meets the criteria of the statute. The commission has applied the 4 factors used in the commuters committee case. If that is in fact the case that we've been using this standard in the commuters committee, it looks to me like this alternate order does not do that. And so why? What is the reason that this order is so distinct that we should not be using our precedent for this? And so that's my initial concern about this. And so what does that mean then for utility in the future when they come to propose an abandonment? Do they try to respond to the commuters committee standard, or is it different now? So want to mention that. I think with respect to the other thing I noticed that is different is just kind of how we describe how we consider the cleaner air emissions. I think both orders consider it. I think the original order, as the RD is written, considers it as part of the commuters committee case, their standard. And this alternate considers it in addition to the statute. Haven't really had the time to really absorb and think about that. And so those are my initial reactions.
Mr. Chair, if I may respond, part of the delay was my inability to type. So it took me a while to do all this. And I certainly thank Mr. Gedko for helping me to cut and paste some things. But that some of the delays my fault. I would say that I think the second order does clarify our policy that we are going to continue to number one, we have to follow the statute. But secondly, I think the computers committee case is being recognized as providing insight. It's a Pennsylvania case. New Mexico courts have not necessarily adopted it. I think there's one reference in a Supreme Court case to it, but it's helpful. And I think each of the 4 categories that are mentioned in that case are addressed in the findings of this second order. The the computers committee says it's going to look at the extent of the carrier's loss of service and relation of that loss to the operations as a whole. We do make a finding that El Paso Electric has sufficient generating capacity from Newman 6 to deal with the loss of the other two generation facilities that are intended to be abandoned. Second category, use of service by the public and prospects for future use. Well, the findings say that we have generation facilities that are beyond their natural life. There's really limited future use without substantial investment by the utilities. So I think we meet that as well in this order. And then balancing the carrier's loss with inconvenience or hardship to the public upon a discontinuation of service. That factor's taken care of with the fact that Newman 6 is online and equals or exceeds the output of these other two facilities. And you have the added testimony that there are at least two other generation facilities coming online in the near future that will expand El Paso Electric's generation capacity. And then the fourth category, the availability and adequacy of substitute service. Well, I think Newman 6 is obviously the substitute service in this case, and that's what the testimony indicated. So I think we have addressed all of the computers committee for factors in this order and made specific findings on each of those. I too would say if you need additional time to review the order, I don't know that we're under any deadline to issue this order today, and would be happy to see maybe a decision at the next meeting to give the commissioners enough time to look at it if that's what they want to do. But the four factors of computers committee are addressed. I think that is a precedent of this agency and will continue to be. But I'm concerned that the recommended decision really did not hone in on the statutory obligations that we're under and felt like we needed to have more clarity on meeting the statutory obligations. That was my sole intent in providing the second version of an order today.
Okay, so the intent was not to move away from the commuters committee standard.
Certainly not. In fact, I think the findings and conclusions follow the commuters committee, and in the discussion we detail that and say that the case should be considered and that a continuation of other factors may be appropriate as set forth therein. So there is nothing in the findings or our conclusions that say that we should disregard the prior precedent of this agency or of our court, although I'd say the Supreme Court decision involving that case really isn't applicable to this case. But it would not be my intent, nor do I see anything in this proposed order that would indicate that we are taking a different direction. And I hope our Office of General Counsel would agree that that's the course that I was on. So that would continue to be the precedent of the commission. It would continue to be something that we would consider, and certainly other considerations can be considered, but our duty as an agency is to fulfill the statutory obligations that are before us. And I think we need to meet those head on and not in a somewhat circuitous fashion.
Okay, I appreciate that. I agree. Especially if the intent here is to continue to consider the commuters committee standard. The other thing that wasn't clear to me is what we're doing with the RD. Because all of the references to adopting the RD have been deleted. And so the RD goes through the analysis, I think, very clearly of the commuters committee, but it also responds to staff's comments and protest. And so this order seems to me like we're not adopting the RD. So then how are we addressing staff's comments?
Mr. Chairman and Commissioner Aguilera, the staff's comments and frankly, the arguments of all parties are well outlined in the recommended decision. The recommended decision is part of the record upon which this order is based. There's nothing in here that doesn't reflect what's in the record. It certainly does not adopt the recommended decision. I mean, this order does not adopt as the first order. The first order basically says the recommended decision is the order of this commission. This does not do that. This finds that we're not adopting the recommended decision, but the recommended decision is part of the record, and it's part of what is the foundation of the order of this commission. It certainly was important. In fact, most of the language in here is actually from the recommended decision, and we do in the discussion reflect that the recommended decision details those arguments. So to the extent that those arguments are in the recommended decision, it's part of the record, and it's part of what this order is built upon. Are we repeating what's in the recommended decision? No. Are we adopting all the language in the recommended decision? No. But it's part of the record upon which this decision is based. And I think the entire record is there for us to base our decision upon. And so it doesn't, I'm not saying that we don't use the recommended decision, but I think our order needs to be clear in meeting the statutory obligations. And that's the intent of this order, was making those findings that were necessary to meet that statutory obligation. And the recommended decision, in my opinion, spent a lot of time trying to justify some things that weren't really in the statute. And is it good? It was a good discussion. It was good to read, but our obligation is to focus on the statutory obligations and not some of the other things. We certainly, I'm very comfortable that those other attributes are fine and dandy, but our obligation is to meet the statutory criteria. So, I make no doubt that this decision, the second order, does not adopt the recommended decision as our decision. So let me be clear on that. But it does not overrule or diminish the fact that it's part of the basis upon which this order is built. If that helps explain where I was at on that.
Yeah, I think I appreciate that. I think what will be difficult for parties, and I don't think this particular case is that big of a problem, because I don't think it's going to be appealed. But just kind of the idea that we like some parts of the RD, but not others, but we are not explaining which ones, is going to make it difficult for parties to know what our reasoning is. And also, I think that we need to respond to the comments. And so it sounds like to me then we do agree with the responses with, let me rephrase that we at least don't disagree with the responses the RD provided to staff's comments. I thought the RD did a good job of answering the problems raised by staff. And so I didn't, I don't want to end up with an order that just kind of leaves some comments hanging.
Mr. Chair, if I understand Commissioner Aguilera's comment correctly, I might take issue with that because I don't know that the recommended decision squarely dealt with or made findings that were necessary to deal with the ultimate statutory issue. In fact, as I mentioned in my initial remarks, I felt that staff's analysis was somewhat persuasive and was concerned that the recommended decision arrived at its conclusion without making very detailed findings that supported that decision, that were in line with the statute. And that's why I tried to go overboard in making it very clear as to the testimony that supported those items that are required for us to make the findings required of the statute. The recommended decision spent a lot of time trying to justify actions based upon clean air standards and things. Well, that's not part of our statute. It's impact of reliability of service to New Mexico customers. And so I grappled with whether or not that recommended decision made appropriate findings to get to the point that would support it had it been challenged, or if it were to be challenged. And so I tried to pick out the testimony that would support the findings that abandonment is proper under the statute that allows us to give approval for the abandonment procedure. And so my order that I drafted is singularly focused on that effort. And it was because I felt that there was some things lacking in the recommended decision. And I was prepared here to argue today that if this doesn't get traction, that we not adopt the recommended decision, but we come up with something, because I think there's some holes there. My opinion.
Appreciate this because, coming into it, I knew that the debate within OGC when they're drafting the order was whether including consideration of emissions was going to add something to the abandonment standard that we use, and really more worried about appeal. And so that led me to think, I don't know what precedent is and what it isn't. So that was, but when I was working through it, and I was just thinking from the point of view of somebody who's done abandonment requests and worked through integrated resource plans and those type of things, I kind of got to the point where whether the decision hangs on emissions or not kind of doesn't matter, because we're the rule, the law that does matter in terms of emissions isn't the abandonment standard, it's the REA. Because the utilities are on a path enforced by that law. They have to consider emissions in the IRP. Emissions will be considered when you do new resources, because those are going to be tied to the IRP law and then again to REA. So I think I absolutely have no issue with including the discussion about emissions in the RD, because there's no way to separate thinking about an abandonment from an acquisition. It's just part of the natural course of action. So I didn't read the RD as saying this decision hangs on the consideration of emissions. It's just that this is a issue that was brought up in the case. And I agree with Commissioner Aguilera. Staff's testimony needs to be addressed. I did not find it at all convincing. In fact, I was going to offer just some constructive criticism or opportunity to provide myself as a mentor to staff that is providing testimonies in these cases. And the reason I think I need to do that is just how crucially important staff's testimony is in the work that we do. They're unique in that they're going to be in every case, and their issue is public interest. They're not an advocate. They're not a corporation trying to make money. They're not any of the things that every other party in the case might be. So we need them there. We need them providing high quality opinions. Whether we adopt their opinion or not, don't know, but really need their voice in these cases. And in this case, staff really did a lot of things that undermined their voice to the point where even the good points that they made were overshadowed by how deficient their work was in this case. And so just walking through that, first of all, context matters. 60-year-old natural gas steamer plants are on their way out. They just are. Eisenhower was the president when these plants got built. There have been 60 years of technology development. What that means is, in contrast to absolutely everything else, these plants are horrifically inefficient. They can only provide reliability if they're on. And so getting them on means starting them up, heating them up. So that doubles down on the inefficiency. Then, the idea of we're going to rely on these things for reliability, forced outages are correlated with age. So that was the question in front of us. Should we abandon this technology that has lived its useful life? And for them to come in and say no, it was just kind of weird. And then, abandonment's also for us, as you pointed out, an economics question, and to address the economics, EPE's been planning to abandon these plants for years. And, one of the pieces of testimony in there is that the plant balance upon abandonment is about $2.5 million. Well, fact of generation of electricity is you have to be investing in that thing all the way up until the day you stop using it. So $2.5 million is functionally zero. So EPE's been planning for it. They've been managing towards it. They're landing in a spot where it's like, how often are you looking at abandonment and stranded asset is not an issue. And then the other is just a trap that people fall into, that we're not going to replace any of these single units with another single unit. The system's dynamic. Everybody does economic dispatch from their portfolio. So just to say, hey, this unit's going down, what unit is replacing it is just not reflective of how planning works or how the system gets dispatched. And then PRC precedent's important too, right? We discussed this, that, relying on that Four Corners abandonment case was misguided at best. I mean, the reason the commission didn't adopt that abandonment was because of lack of specific resources, is because the ETA gives the commission a special power, which is to say no. If you have an alternate that invests in the community that's going to be economically affected by the abandonment, the commission has the ability to say, yes, this is good because it replaces that economic piece. That's a coal plant retirement. It is not Rio Grande, Newman 1 and 2. And then the fact that there are commission precedents where they don't have resources, they haven't been through the IRP yet, they haven't done the RFP yet, but abandonment's approved anyway. First of all, it lines up with your point that the statute says the shall be approved. The other is commission has already made those decisions that, you know, my lack of being a lawyer here, but when I read that, I was wondering, has utility legal division failed in their duty of candor and to the commission? You know, they only talk about this one precedent. It's not the only one that's out there, and it's not the one that I think applies. So all of these things adds up to, first of all, here's the mentorship moment. If you're going to swim upstream, if you're going to argue against the way the world is moving right now, it's going to require more effort. And so what we got was 16 pages of technical testimony in the face of reality. And so it's not just the testimony we got from staff witnesses, it's a failure of the legal division to help these staff witnesses put on a good case. You know, going back to where I started, it's crucially important to the work we do that staff has a voice that it's an important voice, needs to be heard. And in order for that to be heard, you need to be syncing up with a full presentation of the story you're trying to tell. And so legal division attorneys should be helping their staff witnesses and say, hey, 16 pages ain't gonna cut it. In the world of this thing has been planned for abandonment for years in IRPs. Steamers are on their way out. They're inefficient. The commission has already ruled that you don't have to have replacement resources in place. So it's not just on the technical side, assessing the facts and making a stand for public interest. It's also on the legal side to help your witness succeed. And then on the other side, witnesses, if your lawyer's telling you, hey, maybe your testimony is not up to the task, you should listen. Another thing I learned, you know, when I was working at P&M doing this kind of work, you'd get into those situations where you'd have an engineer saying, lawyer, you're not, you know. So what would come back at me was, you know, the old joke that anybody who serves as their own attorney has a fool for a client. So that, I don't know what happened in utility division when they were developing testimony in this case. So, and everybody involved, I want you to succeed. I want to help you succeed. So that's why I'm offering these comments from commission perspective, but then tying it back to where we're at. I don't think we can set aside the RD and not address how deficient staff's testimony was in this case.
In light of the comments, I would say that, Mr. Chair, we probably ought to have Mr. Gidko work with us and come up with an order that meets the objections that we all have expressed today, and maybe it's a combination of the two, but I would suggest that you use the second template, the second order as a basis, and maybe add to it instead of using the first order as the template, adding or taking away from it. Because I do think ultimately we need to make the findings and the conclusions that are in the second order. And I think they are clear. I think they are exactly what we need to reflect to the utilities with respect to the abandonment issue, that we are going to follow, number one, the statute. And yes, we will consider what's in the Pennsylvania case as we deem appropriate. But I would use a second order as a template and try to address the concerns you raised and the concerns Commissioner Aguilera raises and move forward with that.
No, I agree. I think that's a good place to land. And it's funny, these meetings, it's like, don't really know going in what's gonna be, but like sometimes a theme develops and for me, this has been we've got some important cases in front of us, but it's all been about how do we get better and how do we work together to get better. So appreciate that. And then Commissioner Aguilera, did you have anything you wanted to add?
Yes, and I think that approach works. So we can go with that. I'll just mention this as, kind of what the other option would have been, is to find what is objectionable in the RD and then, talk about eliminating that. The reason why is because it was carefully drafted. To point out another one of my concerns, and I don't mean to, just pile things on here, but the statute talks about whether the continuation of service is unwarranted or whether the case presents and future public convenience and necessity do not otherwise require continuation of service or use of the facility. So it's one or the other, but this order in the findings here says and so it's making it continuation of services unwarranted, and whether it is necessary to require the continuation of service for the public convenience. And so that's kind of why, I think the hearing examiners are using, their experience and precedent and writing these carefully. And so just, want to appreciate that, but also want to make sure that those, that those kinds of things are caught as well. Because I don't think the intent here was to say and. I think it's probably or. Yeah.
Mr. Aguilera, I would disagree. I think that in this case, they've met both prongs. You only have to meet one, but in this case, I think they meet both. So they are good under both criteria. And so I think the word and is appropriate in this case. And I think we made findings to that effect.
Yeah, and so clarifying that we think they meet both, but also making sure that one cannot reasonably infer that we're applying a standard that would require them to meet both.
That's a statutory requirement, and
yeah,
I think the fact that we find that they meet both criteria in this case does not set precedent that in every case they have to meet both requirements, because the statute says you only have to meet one prong or the other, and the statute will control anything that.
Yeah, so understanding is we're gonna try again to draft an order. concerns I heard was make sure we address the things that need to be addressed. And then I personally don't think we should abandon the whole RD. So finding the way through that is what we're working on here, but to EPE, expect the request for abandonment will be approved, I guess, because it will be remarkable if after what we just did, you'll get a final order that says something different than that. But,
Chair,
yes, sir.
would you like me to work with a particular commissioner in the next draft, or would the commission like me to take a swing at it and then distribute to all three?
Yeah, I think the first draft. Because, I mean, what we're talking about in the case before yours is being able to work out these orders so that at the meetings, we're talking about the whys and not the whats. Is a direction we want to go. I don't know that we'll be able to get there perfectly and all the time, because again, time's an issue there too. It's not just desire, but. So your efforts are appreciated. Thank you. Okay, so next on the agenda is a discussion of a rulemaking. I will suggest we do our bio break now, just because who knows how long the discussion of the rulemaking is going to be, so. It's 11:22. I'd say let's come back in 15 minutes, so 11:40. So we'll be on recess till 11:40. All right, we are back. So picking up the agenda where we left off, we're in section 10, discussion and potential action. What we'll have today is a rulemaking that's been kind of plugging along in background for a while now. We've had initial round of informal comments, been working through those comments, and part of the reason it's been slow is this is a big rule, not just many pages, but it just kind of affects daily life. And so it's important. And so we're at a moment where Mr. Lundin is ready to present the NOPR on that order. So because it's a long one and with lots of pieces to it, thought let's have a discussion this week, and then that'll give commissioners chance to give Mr. Lundin any more comments on the good work he's already done. And then idea is issue the NOPR in 2 weeks at the next meeting. So that's where we're at. With that introduction, floor is yours. Lundin.
Thank you, Chairman, and please excuse me, I'm a little bit stuffed up today. Allergies.
3% relative humidity does that to me too.
So if the two of you would recall, 2 years ago, the commission discussed at one of its open meetings a plethora of rulemaking opportunities that it had, and determined to set rulemaking priorities. And Commissioner Nyberg, I don't know where you were 2 years ago, but I wager you weren't tuned into the YouTube that day. But Chairman O'Connell volunteered to lead the rulemaking on amending the procedural rules. Kind of like the scope at the time was, obviously we need to update the procedural rules, but also there's lots of opportunity, across that big rule to make changes as well. So we got to work right away, opening a docket. We put out an agency-wide call internally for employees to send in their procedural rule amendments, updates, but also wish list changes. We received internal responses from records, CRD, the hearing examiners, and OGC. They're all very helpful. So this has been a long time in the works, but as Chairman O'Connell noted, it's a significant project and the work has been ongoing. The rule contains 40 sections. In Microsoft Word layout, it's about 45 pages. And they haven't been truly updated since 2008. And at that time, they're so old that in 2008, the commission merged two different procedural rules that dated back to the Public Service Commission. So there's artifacts in this rule that probably go back to, before this agency was even a thing. So basically the procedural rules are sorely out of date. They're in need of amendment, not just for the format, grammar, and style, but to reflect the commission's current state of affairs and current best practices. The commission in 2008 looked a lot different than it does today. So in my effort to bring the procedural rules into the modern era, I've had to propose hundreds of edits across each of the 40 sections, kind of head to toe. I've also been the recipient of many kind of random suggestions over the years from people inside and outside the agency, by email, phone, or in person, requesting changes to the procedural rules. So I've done my best to kind of aggregate all of those ideas and propose them in a prudent way for you all. So there's not any one kind of big singular issue in this rulemaking that we're considering, but for some of the highlights, I will go through some bullets here. So the proposed rule would, codify the hearing examiner's procedural practices, that being their objection procedures, their decorum policy, and the tolling procedures that they implement in dockets, as well as an alternative procedure to tolling. It would cover statements of position. So that would be a requirement for parties and adjudicative dockets to file basically a summary of what their position is. So you have a kind of a centralized place to go for that instead of having to read hundreds of pages of testimony.
It would include uniform pleading style requirements such as font and font size. It would create more flexible public hearing notice requirements. It would provide discovery sanctions. And it would amend the formal complaint process to sort of better resemble a litigated proceeding and to place like greater expectation on complainants in the proceeding to litigate their case. So I've drafted obviously the proposed rule and a no per order to go along with it. As Chairman said, I'm not asking you to vote today, but I'd like to get this on your radar and the public's radar, and allow a discussion of the quorum to inform the next meeting on the 20th. So thank you very much. And that's all I have to say.
Yeah, thank you for that introduction. As you said, it's a long one, a lot of sections, so a lot to work through. I've been working through it for almost 2 years now, and just share for commissioners and for general public when you get your hands on it too. The kind of things that I struggle with is, we're going to use an adjudicative process for our cases, and that has a lot of strengths to it. It helps us really test what's conjecture and what's fact. And then when we get to what the facts are, hopefully we get to a situation where we're sorting among lots of different correct answers to try to find what we think is the reasonable answer. So anyway, that's why that process exists. It works. But adjudicated process also means things like you got to intervene, or you might need representation. So in that world, wanting to respect the applicant or complainant's rights without creating a world where access to the work we do is limited to an only very small elite group. So those are the kind of the big picture things that then when you read through this rule, you can find micro things on each sentence that kind of push you one way or another in terms of having a process that works for the work that we must do versus, how to make sure people can participate, so that's like a big picture question. Another one that we're trying to take on in here is tolling, so that's an issue that's come up in rate cases in the past, that when parties settle a case, and then we still have a job to do. In fact, it's a different job than we had when they filed the case. How does that work? So that's something that we're trying to address here, in addition to all of the modernization things that Mr. Lundin said. So those are the kind of things that I have struggled with when I'm trying to help Mr. Lundin do the work that he's been doing on this thing. So I'm just offering that as observation, and then kind of a preview for looking forward to getting people's comments on this. So, we did ask for comments, but it was a little abstract. Now you're going to get, okay, here's something that we think works. So you'll be reacting to something a little more concrete that might help focus the comments, but we need to revise the rule. Glad we're at this point. So that's what I've got to offer today. Everything, I've been working with it so long, I've been working with you so long, I don't really have any confusion about your draft, so didn't have any questions for you today. Commissioners.
Mr. Chair, in light of a discussion we had a number of weeks ago about dismissals, and I didn't see it initially going through, but do we have something that allows maybe an ability to dismiss cases that are not being prosecuted after so much time, maybe even automatically or without the matter having to come before the commission as a whole? And in light of our prior discussions, I was just wondering if we're addressing that issue, because it seems like we have a lot of cases that are just sitting on the books.
Yes, sir. A provision was added This will be in section 8, subsection J. Basically, it says the commission may dismiss with or without prejudice any proceeding if the party that initiated such proceeding fails to comply with statute, rule, or order, or for other good cause. So hopefully that for other good cause would capture kind of a plethora of reasons why the commission might dismiss a proceeding, such as for lack of prosecution. But it would not be automatic. I think the commission would have to take some action. So if we were to make an automatic procedure, additional work would need to be done on this provision.
Well, Mr. Chair, I'm wondering if maybe we should have some provision that if actions not taken within a time period of our requesting some action, that it be automatically disposed of after a time without having to create another docket matter before the commission. It just seems like there ought to be a mechanism that would allow for us to clean the docket if parties are not responding to our request in a timely fashion, and that it shouldn't take additional commission time and staff time to deal with those matters. So this would be the appropriate place to try to do that if we wanted to have a more streamlined ability to remove matters from the docket if parties are not advancing their complaints or issues, and we've entered an order for them to give us a status of it, and they don't reply.
Yeah, that's a great example of how we can use the next 2 weeks, or hopefully not more, but if we need more, we'll take it productively. Is the way my understanding of these rulemakings work, if it's better to put what you suggested in there now. And then if somebody comments on it and convinces us it could be reworded or should be deleted, that's easier to do. If after we have comments and there's something in here that wasn't in here, there's no comments, we can't just stick it in at the end of the process without creating process problems. So err on the side of inclusion of ideas at this moment. And then the final cleanup will be, oh, gee, man, maybe I didn't need to go that far, or comments have convinced me to take it out. So I'd encourage you to work with Mr. Lundin to get, like what you just described made sense to me. Let's put it in here.
Well, I would do that if there's some sense among the three of us that that's something they'd like to see. I don't want to propose something that.
No, it
you all
makes
would have
sense to me, so that's why let's put it in there. It's not something I would have thought about, so.
And maybe Mr. Cameron or maybe our chief of staff would have some ideas, because I have no idea what the old docket that we haven't cleaned out it looks like. But it sounded to me like few weeks ago when we had the discussion that there were a number of matters that have been just sitting there for long periods of time, and this would be the place to allow a more efficient action to take place without taking tremendous staff or commission time to deal with those matters. So I think it's not just me, but I will be looking to the two people I'm looking at right now to maybe assist in developing that language. So if you guys agree, I'll certainly.
Generally, I'm going to agree with anything that's not in conflict with something else that's in here or seems to be illegal. I didn't hear either of those things being violated in what you said. So that's why I was quick to agree.
Yeah, I agree with as well. And there is, and I'm struggling to find the provision, but there already is something very similar. The only thing I would say is written in a way that doesn't imply that people can file late. Right, because in our orders, we set a deadline, and so that should be the deadline. And I absolutely agree that we have the ability to dismiss a complaint. If people are not taking action or they're missing the deadline, so.
Like, Mr. Chair, I guess there's two issues. Number one, what I was talking about would be after we issue an order for maybe a status conference and are requiring them to respond, they don't respond. That was the case we had several weeks ago. The other thing would be if we have maybe long dated matters that have just been hanging there. Do we want to even issue an order to have a status conference, or can we just dismiss them automatically? And I'm comfortable with we issue an order for them to give us a status and they don't respond. I'm comfortable with some automatic procedure. I may be a little less hesitant to just automatically clean our docket when we don't provide any notice that we're wanting some update. So I kind of would like some direction on that issue if you guys think we need to go there or not, because that was not what I was suggesting. I was suggesting what we dealt with a few weeks ago. We'd sent out an order requesting the parties to submit the status or do something, and then they didn't do it, and then we had to debate whether to dismiss it or not. I'm trying to avoid that. But if the idea is to have an automatic procedure with respect to long dated things, and I see that as a separate issue, but that's not what I was suggesting. So if you want to deal with that issue, let me know and I'll be happy to work with folks, but that's not where my intent was. And I'd kind of like Mr. Cameron and Ms. Corey to tell me what they would like to see.
Yeah, and that's my point is we've got at least a week for you to have those conversations with folks, and then not sure I fully appreciate what it is you're talking about, but what we've been trying to do is, as we move forward, include consequences and why do dockets close in the order we issue, so we don't. But if it's worth it to have a backstop, or if there's another thing that isn't addressed that way, that's possible.
Yeah, and I agree with the strategy of including it now, because once we issue an OPR, we will have some limitation as to what additional changes we can make. And the standard there is logical outgrowth. So, we be able to change something that is a logical outgrowth of something we proposed, but something that is entirely new, we would need a new rulemaking proceeding for that.
Yeah, and then I also have faith in the process here, so if you work an idea through Robert and get the advice of folks like Mr. Cameron and Choya, that whatever comes out is hard for me to expect I would object to it. Again, man who's his own lawyer has a fool for a client, so, although you are a lawyer, so maybe that doesn't apply.
I'm trying not to be a lawyer. I'm trying to be a recovering lawyer.
Yeah, well, you can have coffee with Ms. Corey on that issue. I think. Once a lawyer, always a lawyer, I think is what I'm learning.
Yeah, and I had a meeting with Mr. Lundin, and so we went through some of my thoughts here. One of the ones that I think probably would be helpful to discuss with the two of you is earlier in the complaint proceedings, there are some proposed provisions like requiring the complainant to serve notice to the utility as opposed to us serving it, that I think makes sense on its face, but also makes it more difficult for a pro se complainant to go through the process. And I would rather make it easier. Anyway, that's just something that I was thinking about. I know why we would want that. I think and also I think it is just common sense that something like that would, that the complainant would have that burden instead of the commission. But when we're dealing with just normal person who's a customer and, they don't necessarily have the expertise to go through this. And so, actually kind of like what we were talking about yesterday, I think it was the person from Prosperity Works who mentioned, like writing things in a clear way such that just any person could understand it. That would be helpful in this situation, I think. And so it's kind of that balance. How much do we want to require from just a pro se complainant? I don't know that requires a response. It's just one change that jumped out at me, and something that I probably would suggest we don't make more stringent than it currently is.
No, I think that's an excellent example of what I was talking about, where sometimes hard to read this stuff because I'm in it, so I understand why things say what they do. Putting yourself in the shoes of somebody who needs to make a complaint, how are they going to read this? That's a challenge and requires some work. So that's just a discipline that we're trying to apply to it. And
Well, the rules do make it hard on many individuals to access the procedures because we require electronic filings under these rules. We require certain formatting, and so there are going to be significant portions of the population that would find this procedure difficult. And my response would be that maybe our office ought to be able to provide some at least minimal assistance to those folks and make sure it gets electronically filed and that they understand. I don't think it ought to be our job to do the service, but we ought to have somebody that tells them how to effectuate the service. You have to take this to XYZ address and hand it to the person at the front table or whatever, provide the practical advice and I don't know if we are set up to do that, but if we want to deal with pro se complainants, that would really be the only way to accommodate some of that, at least a portion of the population that may fall in that category, because there may be language barriers, there may be technological barriers, filing electronically for a lot of people may be a real challenge, particularly when they're my age. So we could do some things in the rules, or at least we could do some things within the office that would help accommodate some of those folks. And we need to be careful. We don't want it abused. We don't want people coming in every day just to file a complaint. But on the other hand, people that have legitimate complaints, we ought to be able to provide some minimal level to make sure that their complaint gets filed properly according to our rules and that they're given at least some direction as to how to accomplish some of those tasks.
Right, and the Consumer Relations Division does some of that, and I think, you know, we've also talked about potentially hiring an attorney to help there. And I think there are also things we could do on our website, you know, like a flow chart, and I haven't looked at this, and maybe it already exists, but you know, with a flow chart that says, now you have to serve this notice, and you know, you click on a template of that notice, or you know, just something to make it easier.
Some of those people wouldn't have the ability to click.
Right.
Yeah, to see it.
My sister is a librarian and she was working at Albuquerque Public Library when they first got computer terminals and they had instructions on how to use the thing. And so one of the points was point at the icon with the mouse. And so she was walking behind somebody and they'd put the mouse up on the screen and it wasn't doing it for her. So best intentions don't always work out. So again, that's kind of the discipline we're after here is think about it from somebody who's not in your shoes. But yeah, Ms. Melody.
Yeah, our website does have a 5-step complaint process. However, accessing that part of the web page is not exactly intuitive. This is something that OGC has discussed a few times. But you know, there's 2 different areas on the website to access the complaint. Along the top ribbon, there's a file a complaint button, which will take you directly to the form. But if you go navigate through the consumer relations subpage, there's another file a complaint function, and that will take you to the steps. So in my estimation, it could be done better on our website, and I think at first blush, I think the file a complaint button on our ribbon is not going to take complainants to the steps that explains it. And then if this rule becomes finalized, we will need to amend those steps significantly. So there's work to be done there for sure.
Yeah, and one other problem that we often see is that pro se complainants don't they don't provide the exact like violation, you know, rule section number of this rule. That I think is what is hard for somebody who doesn't know the rules. And so if we can figure out a way, and then we usually go back and, you know, send them a order that says you need to tell us exactly which rule is violated, or you allege is violated. I think that's really where pro se complainants could use some help from us, some hand-holding or electronic hand-holding.
Mr. Chair, my question would be whether or not we should put something in the rules to address some of those issues, or whether that would be better handled just internally within procedures. And it's probably something that Chief of Staff ought to give us some direction as to how to handle that, and frankly, whether or not we are even capable of handling that. In this facility, I don't think we're very well equipped to do a lot of that stuff. Hopefully in the new facility, we would have maybe an ability to do that. At many courts, they'd have a computer terminal in the lobby area where somebody would go assist the pro se person to walk through the steps and guide them through it, get their case filed and get it the information to effectuate service. But we don't have, at least they can't even open the door here without you know, getting into the building. So hopefully some of that will be absolved with our move. But I would be interested to know if we need to do something in these rules, because obviously that have to get drafted quickly, or whether that's something that we can just handle within our own procedures here in the office, so
Yeah, I'm wondering
Corey
if he
might-
paid you
might-
to say that.
might want to give some thought to that issue as to whether or not we need to do something in this rule.
No, I mean, that's a big question that frankly, chief of staff has made tremendous progress on over 2 years is, we don't need a rule for everything that, especially things that are dynamic and subject to change, right? So that's another thing that makes it hard if you've lived with this, just reading through it and thinking, well, this is important to have a rule because it's my relationship with the outside world. Is it better? If it's not that, is it better to just deal with it as it happens? And so those are the kind of things when you're reading it, think through it and again, that's excellent process. Talk to chief staff, talk to OGC and again, this won't be the final version of the rule that we vote on. It'll be the version that we put out there for comments. So if you're in doubt, I'd say include it with, then we'll put in the number, we're asking for comments on this. And so we're telling people this thing might get deleted, but that's just kind of where we're at process wise, I think. So any other questions for Mr. Lundin, questions for each other, or just, I tell you that I'm not a great reader of legal documents, so I can read this like 10 pages at a time and then I have to go for a walk. But anyway, hopefully we'll have this on the agenda on March 20th. So thank you again for your years of effort on this, Mr. Lundin. This phase of your life will be over someday. Okay, so next up is a legislative update, I think, based on who's hovering in the back of the room here. Yep, legislative update, got Jerry Mates. We're down to the final sprint, huh?
Surprised she's even here.
I'm surprised he's not.
I was
bug-eyed
hoping
crazy.
some good news, but somebody decided to debate our simple pipeline bill a little bit longer, so. Do you want me to call him out? Townsend. Yeah. Good morning, Chair. Good morning, commissioners. Right now, SB 9, our Pipeline Safety Act penalty cap is being debated on the Senate floor. And we're hopeful that will pass. It unanimously passed the Senate Judiciary on Monday night. SB 109, our PRC and supporting agency bill unanimously passed its first committee on the House side, and it's been referred to House Judiciary Committee. We're hopeful that it will be scheduled very soon. Our SB 143, which creates the Utility Oversight Fund, has also unanimously passed the House and was referred to House Judiciary as well. And so we're very hopeful that both of those bills will be heard quickly. We're continuing to monitor the progress on several bills that included some tight rulemaking timelines and fiscal implications that would extend beyond what our budget request is. We will continue to work with the sponsors to minimize any negative impact to the PRC, but also ensuring that we can still advance our agency goals effectively. And we have, I think I was told 14 days left. I don't know. Yeah, that's where we're at today. Do you have any questions?
Well, thank you, Mr. Chair. Thank you for all your work up there. I know it's difficult. This is more a statement to the people who regularly appear before this commission, whether they're advocates or utilities or co-ops or other parties. Senate Bill 109 and Senate Bill 143 are important. And most of the advocates and most of the utilities, if not all of the utilities, including the co-ops, have lobbyists. And I would encourage you all to use your lobbyists to encourage Chair Chandler to place those two bills, Senate Bill 109 and Senate Bill 143, on the agenda for discussion as soon as possible, because that will really help this commission, not only short term with our internal functioning, but long term with respect to making us truly an independent agency. So those two things I think are important, and you all could have some impact on the ability of those two measures to succeed in this 60-day session. So I would encourage you to let your lobbyists know and have them contact Chairman Chandler's office and get those things scheduled, because Jerry's waiting on pins and needles to get those things in front of judiciary and onto the House floor. So I would appreciate those efforts.
I just had a question about how many bills that we've issued FIRs on. Do you know? Roughly?
58.
Yeah. Well,
Uh,
I
know that
just
for
heard generally that's been more than we're used to, but I thought it'd be worth it to bring that up just to thank not only you and Chief of Staff, but I know there's a team of folks that get called on to activate immediately when those come in. So thank you to that team. And then sounds like Jason Montoya has been doing a great job of advocating for like pipeline safety bill. So I know we're not done, so it's too soon to hand out awards, but acknowledge the efforts that have gone in and gratitude through to the finish, I guess. So, and also I'm impressed you're not bug-eyed crazy at the moment, so.
Thank you, Chair. Also, on top of the analyses that we've been completing, we've been asked in several instances to provide data to help in determining the fiscal impact to the state. And so I had a compliment this morning that we have a magical team, and we really do, because everybody has their regular work to do. And on top of that, they're providing an enormous amount of data to the LFC to provide information moving forward.
Great. And then I guess we should also include Employee of the Month in that circle of gratitude. As I know John Crankcap's been sitting over there in the Senate Finance hearing room working away while he's still producing good work here. So
I'll just echo my thanks to you and Choya and everybody else and Commissioner Nybert and the chair, who've been also very involved in making sure this agency is taken care of at the legislature. So thank you all. And I'll be chaperoning my son's field trip to the Roundhouse on Monday, the 17th. So I'll wear my nice pin that I have now.
as you know, every day is Irish American Day. Anything else?
No, Chair, Commissioners, thank you very much. And I'll just keep you updated weekly,
Great.
if not sooner.
Thank you.
Thank you.
Already in 14 days right now.
Yeah. Yeah. Sine die. All right. Next up is communications with Chief of Staff.
Good afternoon, Mr. Chair, Commissioners. There is a lot happening at the PRC right now. So I just picked a couple of highlights to update you on. One, on a personnel matter, I want to thank our IT Director, Brian Woods, and recognize what work he has done with us over the past year. And also announce that he is going to be moving on to his next opportunity, to the next adventure. So wish him luck in that. He's done amazing work filling out the IT division. We now have all positions filled. He's done a lot of progress getting us to better IT security and IT processes. So we're really grateful for that work. And this relates to the next thing I'm going to tell you, which is we will be filling that position. That is not one that we will be holding, which segues me into the next thing I wanted to talk about, and just touching on budget. Our legislative team, including Miranda Mascarenas, our CFO, we're watching HB2 like a hawk. It went from the House over to the Senate. It's currently in the Senate right now. It did not include everything we asked for. In fact, the House version of it included barely anything we've asked for. And so we're really, frankly, concerned about it as it sits. And we are doing what we can to make sure that changes to reflect our needs and the full ask that we went back and asked for after our meeting with the LFC commission, or excuse me, the committee in the interim. But because we don't know what it looks like, there will be some positions that we are going to be holding because we need to see what FY26 looks like before we post and film. So good news is we will know shortly because the session is wrapping up before the 22nd. So as we watch that, just know that some of the positions will not be filled. There are other positions that are critical, or more critical, I should say. They're all critical because we're operating on a skeleton crew already, but those positions like the IT director will be some that we do intend to fill. Also, if they are posted currently, we do have the budget to fill them. So some of the, I'm going to say harder to fill positions like the engineering bureau positions. So that's an update on budget and personnel. And I also wanted to take a moment in this opportunity to chat with you to recognize that we all have been deeply affected by what's happening with the state of our world at the federal level. And many of our employees have been, and their families have been directly impacted by what's happening. And so I wanted to take this opportunity to remind ourselves what we do here and how important it is for the world, for New Mexicans. I'm truly grateful to be serving alongside such dedicated public servants as yourselves and every member of this incredible team. It's refreshing, I guess, to remember that our agency is mostly funded by the state government, not reliant on federal funds. It's important to know that we operate and are formed under state law, not federal law. And so what that means for us is we can continue to do the good work that drew us to public service in the first place. And so as we move forward, and so many of us are facing uncertainty or struggling with what we're seeing, I just want us to remember that progress is still happening and we can continue to do what we're doing here and make changes in the world and put good out there. And so recognizing that this could be a very hard time for many of us, I want to take this opportunity to thank you and thank the team that we work with every day here at the PRC, and just know that we're all in this together and we're going to keep changing the world right here at the little PRC. So with that, I don't have any other updates that are worth talking about today in here, but I do stand for questions. Thank you.
I don't have any questions. I appreciate that sentiment and agree with it and could not agree with it anymore. The work that staff here do is valuable, and public service is valuable. And so I just want all of the staff here to know that that they're appreciated and that their work is important. You know, I've been a public servant my entire professional career. So I think I can say, you know, just based on my experience, how much I appreciate the service that is provided. And uh, I think that it, as difficult as some of, you know, like the HB2 could be, we do have support for this agency here at the state level. We're doing really good work and we're improving every day. And that is really encouraging because we're headed in the right direction. So thank you for your public service. I appreciate it. And even though the general public might not really recognize it, you know, I think they might when they face like public safety power shutoffs, but it's just thank you is all I can say.
I just hope you'll put me on your schedule so I can work with you on the things that we talked about on the rulemaking. But thank you very much.
Thank you. Okay, so last bit is communications with commissioners. Would you like to lead us off, Commissioner Nybert?
No, I just would like to thank my fellow commissioners for getting me to a national organization that provides a lot of education, and my head exploded in Washington, D.C. with all the information that they were providing, and found that it was a good conference, worthwhile, and there's several others that they've encouraged me to go to, and I'm trying to get up to speed with you guys. It may take me a little while, but I feel a little more comfortable today than I did 2 weeks ago or the 2 weeks before that, and appreciate your patience with me. And again, it's a lot of learning, and I've told everybody who's asked, this job is a lot bigger than I had ever anticipated. This agency and its work and its workload is a lot more extensive than anybody outside of these walls would ever recognize or appreciate. And it's not until you get inside that you see how big it really is, and how many cases come before the commission, and how much work goes into each of these decisions that we're making, and how many people and how many areas of expertise are required to get to the decisions that are made by this commission, and frankly, recognizing that it affects every citizen in the state of New Mexico. And so I just am overwhelmed with the breadth, with the dedication, and with the expertise that exists within this agency, and cannot be any more appreciative of the efforts that they've made to make my entry welcoming, and also to provide me with information that is trying to get me up to speed. So thank you all.
Yeah, you just reminded me the moonshot challenge wasn't just send a man to the moon, it was also return him to Earth safely. So the struggle is real. Commissioner Aguilera.
I was at the NARU conference as well, and you know, had an opportunity to have good conversations with people, and also, you know, just catch up with friends. Aside from that, I'll be going to a workshop or conference put on by UC Berkeley. There are a couple of papers that have been put out by some of the professors, and so it'll talk about those, and you know, ask some questions about them. I don't know how tough I'm supposed to be yet during this panel, like my questions, but I guess I'll figure that out. And I think that's all I have to report for right now.
Okay, great. And then I've got two things I'm gonna be doing between now and the next meeting is worth talking about is on the 11th, Tuesday, I'll go to Salt Lake City for the WEC Member Advisory Committee meeting. That happens like the day before, the next day's a board meeting. All that stuff's available online if you're interested. One of the things I find when you go to these, just the cadence of how the WEC works is in front of the MAC meeting, which will be at like 3:00, 3:30. They always have a technical session, so WEC picks some topic that's relevant across the WEC and has a hour of presentation on that topic. The one that's going to happen on Tuesday is on large loads. So coming out of NARUC, there was two big topics. One was what's going on in DC. The other was load growth. So you'll get the WEC perspective on large loads and what that's happening across the West. And then the other thing that thought's worth highlighting is it ties back to what Chief Staff Corey was saying. I mean, one of the reasons I'm here is because action happens at state level. And if you're talking about electric system, it's balancing area by balancing area. So participating in WEC helps remind you of that. So if you're wanting to see how your work matters or how what you're doing ties to the bigger world, paying attention to WEC meetings is one way you can do that. And then the following week, I'm going to go to Nashville. President of the RSC is a attendee at Southwest Power Pool's annual strategic planning meeting. So that'll be 18th and 19th. Or 19th and 20th. It's 19th and 20th. And so that's why I've asked that the meeting starts at 11:30 because first of all, I'll be there working, helping SPP think about their next strategy. The one they've been working with a strategy they developed 5 years ago. They're going to do the next version of that. And so this meeting is a piece of that. So provide regulator and state perspective. Like I want to make sure I have written down when was the last time somebody was interconnected, but so I'll be calling in to the meeting on the 20th because I won't be able to get back by then. So thinking of just designating Commissioner Aguilera as chair for that meeting because you two will be here in person. But so unless you've got a overwhelming need to chair the meeting, because I'm sure he'd be happy to let you do it if you want to. But so anyway, that's just context for why we're doing 11:30 on the 20th is I'll be calling in because I'm at the SPP strategy meeting. So anything else? Oh, we have an update on SB9. Breaking news from the legislature.
Commissioners, SB9 passed the Senate floor.
Oh, okay.
That's the pipeline safety penalty.
All right. Well, that's good news. Thank you. And then that was the one that Jason Montoya was critical in getting across the line. So
I have one more thing that I forgot to mention. I extended the NARUC trip by 1 day to attend the Hispanics in Energy Conference. And they gave me an award that says outstanding regulator. I don't know what the criteria was for all that, but it was a nice surprise. So
congratulations. Okay, so again, like I say, these themes developed during the meeting. This one seemed about let's take another step forward in how we work together. So always down for that. So thank you all, and we are adjourned.